Hello, everyone. Good afternoon from here, good evening, good morning, depending on what part of the country you're calling from. We're just here now. We're about to start. Hello, everyone. It's not your time. Good afternoon from here, good evening, good morning, depending on what part of the country you're calling from. We're just here. Okay, I think that's the life going on. So it was coming back at me again. We have a gentleman here who is already waiting. By the time I opened, he was already waiting. I think I'll go ahead and admit him in, even though it's not yet time. For me, I'm very serious about punctuality. It's something that it's very key, it's very important, and it's something that we all need to imbibe and really work on. It helps a lot. It helps up in terms of doing the things that we need to do. If we want to do things right, we need to be very punctual about it. I see, of course, my YouTube friends are already on, and they're already waiting and they're already listening. Hello, everyone. It's not yet time, but hey, we'll start early while we wait for people to come in and join. And what I'll be doing also is that Justice, I don't know if you can hear me, but you've not enabled your audio. You've not enabled your audio, so that's the reason why you can't hear me speak. But we're here. And while we wait last week was such an interesting moment. And I'm so sorry, apologies to everyone. We were supposed to have edited parts of our last week's speech. I gave it to my assistant. She hasn't been able to conclude on that task yet. The people that we're supposed to have work on it. Unfortunately, they failed us at the end, and then we're still trying to get in people that we can that can edit, help us with edit and all of that. So please, if you're also a videographer, let me know what it is. And I hope the prices are not too crazy, because sometimes you're spending so much money on this. It's really it's unbelievable. And I think it's from last month, I'm actually like, oh my goodness, I'm having to live with a budget. For the last over 20 decades, I've always had access to my company money. I mean, it's always there. As a trader, you cash, they don't come up for your hand if you do trading. But just this last month, what I did, I've separated myself from the business, and I think I have fleeced the business too much to pay for my advocacy and the things I might pay my bills and all of that. So now I have to be very mindful of the things that we do. So hey, yeah, today. So if you have like a videographer, so let me see. Hopefully the prices are not too much, because there were so many gems from our last week conversation. Hearing Inibehe, talking about it was almost like a classroom, being educated on the different things that were going on. So it's really something that we need to cut out, edit part of them and put them in. I can do rough edit. I mean, it's so taxing. I have a lot of things. I'm working here. I'm doing my fellowship full time. I'm researching. I'm working on what I'm going to bring out at the end of my fellowship and stuff like that. Of course, with the different calls back home, different meetings and a whole lot. So it's so much. And I needed to just delegate. And the people that are supposed to do it ended up not doing it. And so we're on it. But I think these are things that we need to have. Justice, you are enabling your video, but you've not enabled your sound. You need to enable your audio. You need to enable your audio. So we can hear you. I don't know whether you can hear us. Yes, I think you've enabled your audio right now. So, okay, I see another person also is coming in. And so, yeah, that's good. So we are 1 minute. It's 1 minute towards the time that we need to take off. Hello, Justice. I've asked you to unmute. Go ahead and just give us your own take. Why did you come in so early? Were you here last week? Was this such an interesting conversation? Go ahead. The floor is yours.
Wow. Thank you very much, Madam Aisha.
Aisha is okay. Aisha is okay. I'm good with Aisha.
Okay, good. It's a pleasure and honor to be on live with you. I missed last week.
Ah.
I put my reminder on, but somehow I got so busy that I missed it. And so when I saw that you tweeted that you would be on air today, I did the same thing. I put my reminder on, but I had to stop what I was doing early to make sure I don't miss today.
Oh,
that's the reason I'm here. I'm here on time, and I'm waiting to digest everything you and our barrister friend would have to give to us. It is a pleasure one more time to be on air with you.
Thank you so much, Justice. It's really a pleasure hearing from you, and thank you for making the time out and actually putting in the efforts to be here with us. It's a pleasure having you here. So thank you so much and welcome. And this week, so like I was saying, hopefully towards the next week, I'll just cut out some of the things that we had done last week and just put them on YouTube so that others can just go in and have a look. It was really an interesting session that we had and very educative. Very, very educated. So welcome, Justice. Thank you so much.
Thank you very much.
Well done. Well done. So that's Justice. As you see him putting in the effort to be here. Last week was actually very educative, and it was something that I think everyone that came on would admit was such an eye-opening session and such a needed session. Because in everything that you do, knowledge is very, very important. When you're knowledgeable about something, it actually helps you to really do so well. And it's really something that in everything you're doing, just try and get that knowledge and then come from the point of knowledge. While we're waiting for Barrister to join us, I called him earlier and he did say he was waiting. Let me find out. Hopefully it's not having any problem joining like it was with the last time that we had the session. There was so much problem for a lot of people to join. Not too much of problem, just a bit of technicalities that I deliberately did put some of those things there, because sometimes when you're the Zoom is published publicly, so you need to have certain sort of measures, security measures, in terms of being in the waiting room, in terms of you have to be registered on Zoom, in terms of stuff like that, so that you don't have people just coming in and disrupting. Because I've had public Zoom meetings like this, and then sometimes you just have people come in, disrupted, put a lot of things. Sometimes they put inappropriate messages, put inappropriate videos and stuff like that. That's why, to an extent, the last few days they were like people couldn't put on their videos, but right now, the capacity to put on the video is there, so that we'll see people's faces when they are speaking. So we'll see how it goes. We'll really see how it goes. And so thank you so much for those who have joined. We're waiting for our guests to come in. And of course, to our viewers on YouTube, you guys are always representing, you guys are always showing, you guys are always there. So now, well done. Thank you so much. And we're waiting for Barrister to come in, and hopefully people are not having a bit of network issue. So let me just hold on. Let me go get him and lay my hands on him and get him over. Thank you so much, everyone. Hello, for those who are just, okay, Barrister is already here. I just saw. I'm admitting him in right now. And then for those on YouTube, I'm going to just share our, so Barrister is in here, but he has not enabled his speaking this thing. He has not enabled his audio so that we'll be able to hear him, and of course he hear us. I'm going to share how you can join the Zoom. So for those who want to do a contribution or one thing or the other, you can easily do that. So I'm copying and I'm going to put it out there. Okay, yeah, we have people are coming in now. People are joining, they are joining us. So get ready. If you've not, while we're waiting for all of that to happen, please go get your, but some people are just dropping off. Okay, yeah. Please go get your paper, your biro, get the Constitution, also get the Electoral Act. These are things that are very important for this conversation. So for those of you on YouTube, I'm currently putting in the link, the Zoom link, so that you can join in. So what will happen, I'll just pin it there so that you can join in and you can ask your questions. Although you can still ask your questions on YouTube also. I can easily, we read them out. Yeah, pin message. So if you're on YouTube, it's already there pinned. Okay, yeah. Welcome, Barrister. I'm seeing you. I think people are just coming in at this time. Okay, what's happening now? Yes. Okay, fantastic. So, Barrister, you're now a co-host, so you can go ahead and unmute yourself. Let me know, can you hear me?
Yes, I can.
Okay, fantastic. Okay, fantastic.
I can hear you.
Okay, that's great. So I think I think we're ready to kick off. We're ready to kick off the session. Those on YouTube are already waiting, and then people are just gradually coming in here, joining our Zoom conversation. I think it's important we just kick off. Thank you so much for agreeing to do this again. You were here last week, and it was such an interesting moment, a lot of teaching moments that we had. And I knew I took my notes. So before we go on, please, for those who are here, go grab your Constitution, go grab your Electoral Act. If you don't have your, my video is not here. Let me enable my video. Okay, go grab your Electoral Act, go get your Constitution, get your paper and your biro, because you will need them. You will need them for all the lectures that we are going to get. And from last week, we had quite a number of interesting conversations that we had in terms of looking at what overall petitions are, what are legal votes, and the different things that we had on. And it was really quite an interesting and educative conversation that we had. And hopefully this week again today, we are going to have that, and we have a great and amazing conversation. For those who are on YouTube, at any time you want to join in, the link is there. Just come in here, put in your questions. If you have questions right now, you can write them on the chat group. When our barrister is done with his conversation, we'll come together and go back in. He's a human rights activist, he's an author, he's a lawyer, of course, and a whole lot of things. Like we did explain last week. I will hand over the mic and the floor to our barrister to take center stage. We are all here to learn, and we're really, really happy and willing to be tutored and to learn and to get the knowledge to be able to do everything we have from a knowledge-based point of view rather than from an ignorant-based point of view. So thank you so much, Barrister Inibehe Effiong, for agreeing to come in today, and the floor is yours.
Thank you, Aisha. I actually prefer Mr. or just Inibehe. I don't do quite
let me
Yeah,
Let
I
me
don't know.
give you a secret. I'll be calling you Barista alone. You know why? Because that your first name, it's intimidating. Inibehe. It's not supposed to be difficult, but it's so intimidating. So that's why I'm sticking more to that Barista and this thing. But okay,
Yeah.
noted. Well noted.
I don't do very well with appellations, with titles. But that's
yes. True, same here. It's so limiting. Thank you so much.
that's fine. So I welcome everyone who has joined the discussion today. I'm hoping that at the end of it, we would be able to go home with 1 or 2 points to further widen our knowledge of the subject of discourse. In the first part of this discussion last week, we did examine a wide range of issues related to the election petitions, which are currently before the courts. And I did offer clarity on those issues. And I hope that as we further discuss today, again, that we would find a conversation worth the time devoted to it. Now, last week, which of the Peter Obi is joining, please? Aisha, you are muted.
No, I don't know which of the Peter Obis is that because I did not invite Peter Obi, but
okay.
it could also be passing to if he said it and he joins, but I didn't invite Peter Obi. So I don't think.
Okay, because I saw.
Yeah, I did see that too.
Yeah. Okay, someone is asking what is delaying the court case from starting. I think I had answered that question last week, but let me just further clarify that the tribunals in the country, the Presidential Tribunal, that is the Court of Appeal, which sits at the Tribunal for Presidential Elections, and of course the other tribunals in the country, they have a timeline under the Constitution, Section 285, which is 180 days. The time for the actual hearing to commence is also one that the law has specified. So what happens is that when the petitioner has filed the petition, of course it has to be served. When it is served on the respondent, and then what will then happen is that the respondents will be entitled to respond to the petition. When they have responded to the petition and all the issues are joined, in other words, when the pleadings are closed, that is when we will have what is called a pre-hearing session. It is at that pre-hearing session that there will be a scheduling. The tribunal will now set the time frame on how the proceedings will proceed, how the hearing will take place. We have not gotten to that stage, but we are close to it. But one just has to wait because all the parties are entitled as of right to respond to the petition that have been presented against them. So that explains why the process has not commenced, and I indicated that for the Labour Party petition, I'm not quite sure. I am aware that they had a challenge with service of the petition on Asiwaju. And because it could not be served, they had to go back to the court to obtain an order for substituted service to enable them serving. When that is done, that is when they will be able to respond. So when they have responded to the petition and
Inibehe, your network.
The respondent has 21 days to respond. That is the respondents in this case. It's not stable.
Yes, it hasn't been stable, but it's more stable now. It was dragging. So let's go on and see how it goes now.
Oh, let's hope that this stays well. Yeah, so I'm essentially saying that the respondents have 21 days within which to respond to the petition, right? And when they have filed their reply at the tribunal, the petitioner, of course, will also be entitled to also, file his own response to what the respondents have filed. When all that is done, it is deemed that the pleadings have closed. And then we will then proceed to the hearing. So that is why hearing has not commenced. But I know that we will still have to wait for a while before that can be done. Yeah, so at the first part of this conversation, I had laid the fundamentals. I did state what an election petition is. The persons that have the local standard, that is the right to approach the court to present an election petition. I also explained the grounds under the law, particularly under Section 134 of the Electoral Act, for presenting an election petition. And then I went further to link those grounds to the petitions under review, the extant petitions before the tribunal, and carefully summarize the issues canvassed by the petitioners. So today, I would love this to be more interactive. I would like to take more questions today. The intention is to be certain, or relatively so, that the issues that are being considered are ones that are beneficial to participants. I don't want to make this a monologue. I don't want to be interacting with myself. So I will welcome questions. There are questions or issues for which clarity is required. I would join everyone, or those who have those questions, to indicate. They will be given the opportunity to ask. I believe there are two ways to go about that. Either at the comments in the chat or in the chat box, or then you can be unmuted to speak and ask the question. So having said that, I stated that the election petition is a very delicate matter. Part of the confusion that we are seeing on social media is because of the very technical nature of election petition. It is actually an area of law that one has deep interest in it, and also some work in terms of experience to be able to speak to the issues that count. Much of the debate, much of the things, some of the things we are seeing on social media may not really have bearing at the court. Because as I keep saying, for lawyers, the attitude to matters has always been people in other professions, how people in other professions will approach it. So lawyers are very, there's a methodology that one has to adhere to. There are principles that the law has established over the years that one is expected to comply. I also indicated that the job of the petitioner is not a trivial one. It is not an easy one. However, there have been precedents where the courts have nullified elections, particularly gubernatorial, or specifically gubernatorial and legislative houses elections. What we have not witnessed in the history of our country is nullification of presidential election. The closest we have experienced in recent times was in 2007, when the Supreme Court, in a split decision of 4-3, 3 justices of the Supreme Court, including Ogunchade, nullified the election that brought the late Yar'Adua to office, while a majority of the justices affirmed the election. That is the closest that we have had. Other than that, if we look at from Awolowo, Shagari, and all the presidential petitions that we have had, Buhari and Obasanjo, Buhari and Yusuf, Buhari and Yaradua, and several of all the cases, article cases, and so on, the Supreme Court have been very consistent in affirming elections and dismissing petitions that are brought to elections. Whether this particular year will be a watershed will be different. It is left for time to reveal. But what is important is that the process and the machinery of justice is there. It has been activated. It will be left for us to wait and see what the outcomes would be. So having said that, if there are questions at this time, I would want to attend to them. Otherwise, I will continue to shed more light on some of the issues that I indicated or spoke to last week.
Thank you so much.
So, comrade, over to you.
Oh, thank you so much, Inibehe. It's really interesting hearing all of that. I think there are some questions that have come in. Why can't I just see the chat anymore? Okay, yeah, there are some questions. Okay, someone is asking, though not directly related, is asking, why can't the swearing in be postponed until after election tribunal? And also, how will the tribunal deal with power of incumbency when Tinubu is sworn in? These issues are pertinent of concern to many. How can we deal with this? That's what in the chat. Do you want to take that, or you want me to read more of the questions coming in?
No, I'll rather take them one at a time. Well, okay. That is a question that many people have asked. The truth of the matter is that under the present legal regime, there is simply no allowance for any process of law that can stall the swearing in of the person declared by INEC. That is the truth of the matter. Whether you are speaking in terms of the Constitution or the Electoral Act, what the law says is that you have the right to present a petition to challenge the return of the person or the person returned as elected by INEC. During the currency or the pendency of that petition, the person is allowed to remain in office. And then the courts and tribunals will then adjudicate on the matters brought before them. Now, is it possible for an injunction to be granted? The answer, honestly, is no. I don't see how that is going to happen. But this is Nigeria, right? A lot of things are possible in this country. Where we have seen court grants injunction that are ordinarily non-grantable in law. We have seen quite controversial. But to issue an order stopping the swearing in of the person declared by INEC is also of why, let's assume such an order is made. The question is even which court is going to make the order. Is it going to be the regular court? That is not likely to happen. Is it going to be the Court of Appeal that is hearing the petition? And who is going to even bring the application for that to happen? I think people should just invest their emotions on what is legally realistic so that one does not get high blood pressure on account of petitions. Now, the Court of Appeal is not going to grant such an order. And I can assure you, and the PDP article, they will certainly not bring such an application. If such an application is going to be granted, it will have serious ramifications for the quality.
Inibehe
is going to be the question of vacuum. Let's assume, yeah.
Okay, I think
yes,
your network is dragging. Is it possible for you maybe to just go out and come back in again and join?
Can you hear me?
Yes, I can hear you, but it was dragging. So
okay, that's fine.
Maybe if you just drop off and then come back again.
I'll just
and check
yes,
the
please,
sometimes
yes.
it helps. Okay. Hello, everyone. And if you're just joining us, welcome. We're actually having a conversation with Barrister Inibehe Effiong. He's a human rights lawyer. He's also an author. He's an activist. He's one person who has really been out there taking a lot of public interest cases and ensuring that, justice is gotten. He recently got justice a ruling in favor of his client. And this client was the person who during October 2021, when they were doing the 1-year anniversary of the Lekki massacre, and he was an Uber driver who was just within the vicinity, and then police took him on, arrested him, attacked him, and that video sort of like went viral, and he went to court with the case. And he was able to get judgment in favor of his client. And the Lagos state government has also agreed to go ahead and pay the fine. I think that's about 5 million naira. We've been having a conversation on the election petition, the 2020 and also the 2023 presidential election that was just concluded. And basically, we've been having this conversation in trying to understand election petitions and Nigeria's 2023 presidential election. This is part 2 of that conversation. Last week on Saturday, start 6 p.m. Nigerian time, live with Aisha. We had him here. He was our guest, and he actually took us through the ropes of what election petitions are, and also looked at some of the petitions that are out there, mainly that of Mr. Peter Obi and also Mr. Atiku Abubakar. So we are continuing the conversation today, and he's looking in depth at some of the petitions and also what they're involved in. I will take in questions. You can put up your hands, you can send in your questions. There are people on YouTube who are currently watching. It's also just send in your questions, and then we get to a place where people will be unmuted to speak and ask those questions. So he has dropped off, and we're waiting for him to come back in so that we'll have a better, how do I put it now, a better transmission, because a little bit it seems as if the network it's not going the way it should be. But before he comes on, it's for us to say, this is a critical moment in Nigeria. And when we talk about critical, there are certain stages in every nation's history where they get to a critical moment where, depending on what the citizens do, it reflects on the direction and the projection of the nation. And I think this 2022 election, and at this juncture, we've gotten to that place. First of all, the citizens of Nigeria did all the things that they needed to do. They participated in the electoral process. They came out, they campaigned, and they went to the polls to vote. And what happened, it's no longer news, because these are things that were done in the public domain and were done with impunity. And we've come to a place right now where the cases have gone to court. And one of the most important things that citizens must do is to ensure that they are taking on the judiciary. In the last 2 decades or more, the advocacy of citizens, the focus of citizens, the attention of citizens has always been on the legislative arm of government and also on the executive arm of government. The attention has not really been on the judiciary. And so this is the time for every Nigerian citizen to focus that attention on the judiciary and ensure that the judiciary becomes the last resort of the common man, the last hope of the common man, and no longer the last hope of corrupt politicians. And so, look, a lot of people have said, oh, petitions don't matter because, these people will do whatever it is that they want to do. The judges always go in a certain way, but that's because we've not focused on them. That must not be the mindset that we are looking into. What we must be focused on is, what are we going to do to ensure that justice is what is done? And this is that time when Nigerian citizens should focus on what on ensuring that justice is gotten. So I've seen some of the charts here. Someone said, I think Aisha can answer some of the questions here too. Okay, let me look at the questions that I know I can answer with my limited knowledge. Looking at Gloria Okereke that says, what is the age limit to contest as the president of Nigeria? Because there was a newspaper publication in 1998 that Tinubu was celebrating his 52nd birthday, and today he's claiming 71 instead of 77. There is no limit to what age someone can be to be president. There is a limit to at what age you can aspire for that post, but I don't think there's any limit. But of course, we have our barrister come in and also answer that question. That's not something that can be done. So I see a hand up, Joe Mas. Let me see. Okay, let me try and get this. Can you go ahead and unmute yourself? Okay, I think I've muted that. It doesn't look as if it's a so if you have a question, while we wait for barrister to come in, go ahead, please. And if you want to speak, just raise your hand and let me bring you on. Before I go look for him and see whether he's having problems joining us in. Motorola One, you're supposed to raise your hand using the chat, not physically raise your hand, because it helps me to be able to find you. Felix Tipo, go ahead.
Hi, Aisha. Good to see you again. Like I told you, we're still waiting for you in Dallas. Hopefully one day you can stop by.
I hope
thank
so
you so
too.
much. Yeah, thank you so much for all you do. We really appreciate you. It's people like you that is giving us hope to even keep doing this. So whatever you do, I pray that God will bless you and protect you and your family, as you do this. So
Felix, if you can put on your video, you'll have the capacity to do that.
Yeah, I'm actually at a place where I can't put on the video now.
Okay,
so yeah, I'm sorry. Okay. I would have loved to, yeah. But my question though is this: I've been following this David Hundeyin, this guy that is doing an amazing job. He's a journalist. And one of the things he's been talking about, I'm sure a lot of people have heard about him, is the issue about Tinubu's alleged drug case in Chicago and the school certificate that he presented to INEC, and the fact that it is alleged that the certificate that he presented is a fake one because it is absolutely different from the one that they got from the actual school that he said he went to. So my question though is, if it is determined that the certificate that he presented, because you could see that the font, the logo of the school, and the number of signatures on that certificate that he presented are totally different from what they got from the actual school. If it is determined that the certificate he presented are not real, are forged, how does that impact his candidacy to the presidency of Nigeria?
Okay, so much. Thank you so much, Felix. So I was just trying to call Inibehe. Apparently, he was actually waiting for me to add him on, and I didn't see that people had come on in the waiting room. Okay, yes, your question well noted and well taken. And while he comes in, I'll just brief him on it. The drug issue is actually part of the petition. What do they call it? Prayers? Is that what they call it? Oh, yes. Let me.
The grounds.
Hello,
the ground.
You're fantastic. You can hear me now, right? You're muted, right?
Yeah, it is part of the grounds.
Yeah, the drug. So he's also acting. What about the issue of his certificates?
I think that has been raised in PDP's petition, but not in Peter Obi's petition.
Okay, okay. So that's the question. Just what before you came in, Felix Depot was asking that they are raising that the certificate that was Tinubu presented was not the same that with the one that came from the school, and also the drug issue.
Well, regarding the certificate thing, is it's very dicey given the position taken by the Supreme Court in the case of Atiku and Buhari in 2019. You know that what the Supreme Court said regarding the eligibility of Buhari in terms of his qualifications. Now, whether the courts will now give a different position to Buhari's Tinubu's educational qualification is left to be seen. What is important is that in the form that he filled with INEC, he had stated and indicated what he said is his qualification. The Constitution says the person must have been educated up to at least school certificate level or its equivalent, right? So if I go to INEC and fill a form and say I have a PhD in law, that is what I have said is my qualification. If that PhD in law is genuine, it may not matter that okay, let me not use myself. It may not matter that the candidate who said they had a PhD in law actually did not have a primary school or secondary school. Again, this is part of the issues with our legal system, right? Because educational qualification is supposed to be like a pyramid. You are not supposed to jump to be a doctor, a PhD holder, if you have not had a bachelor degree.
Can I just come in, Inibehe, can I just come in here?
Yes, please.
Yeah, to say on this issue of educational qualification, I've always found it, first of all, it shouldn't even be a court issue. I think it should be a legislative issue. Because if you go into and correct me if I'm wrong, and that was why in 2014, when that whole issue, I kept saying, we need to focus on our law, because I think there's a part where it said, if INEC can ascertain that you can read and write, you don't even have to have gone to school or something like that. If they can ascertain you can read and write, then that allows you, that gives you, then you can run or something like that. Is that factual or that's not?
No, that cannot be correct.
Okay.
That will be setting fire on the Constitution.
Exactly. So what is the way that it is? But what about
the Constitution does not say you have to be,
or its equivalent?
No, the Constitution does not say you have to be literate. It says you must have been educated. Education is not a spiritual thing. Mm-hmm. It is not esoteric. It is not something you acquire in the dream. It is scientific. It is empirical. If you have been educated up to this level, there has to be something evidencing that fact. There has to be document, certification that speaks to that education up to that level. And how you do that is by producing your certificate. So let me just ask you, what part of, can you give me what part of the Constitution, what section is that talks about it? I just want to quickly look at it. The qualification for president. Yes. Check 130. Okay. 131. Yeah. Okay. Okay, go ahead. Check 130 and 131. Okay. Yeah. So I'm saying that you would have to basically meet those requirements, right? So you don't go to court and say, I am qualified because I can read and write. Tinubu is saying that he have you seen it? Yeah. What section is it? Section 131. Yeah, 131. 31, yeah. Subsection D. Yeah. So you don't go to the court and say, I can read and write. That is not what the Supreme Court said. In Buhari's case, they actually accepted his controversial WAEC certificate. That is the truth of the matter. That was the basis of the judgment of the Supreme Court. In addition to what they said were his training in the military, which they said was equivalent to so and so. Look, I have my own reservations about whether Buhari had a certificate or not. For me, it is even an aberration. And like you said, this is also a legislative problem. I don't understand why in a 21st century Nigeria, somebody should be president in a well-literate country with secondary school certificate. It makes nonsense of graduates that have to go to university, get masters, get bachelor's degree, and still cannot find jobs. But somebody with primary school can become president. It doesn't make any sense. Mm-hmm. But then that is what our constitution says. So for you to prove that Tinubu is not eligible, right? Because he has presented a document to INEC saying this is the basis of my qualification. Tinubu is not saying I went to primary school A or secondary school B. That is not his qualification. He's saying Chicago State University issued this degree in accounting to me. That is what he's saying. Right? So if you now go to the tribunal and say, oh, in year so and so, when he contested for governor, he had deposed to an affidavit saying this is his qualification. Well, that is in relation to that election. That is what his lawyers will tell you. But regarding the 2023 elections, the qualification that he has presented, because it is the candidate that says what qualifies him. It is not INEC that says this is what will make you eligible. It is you who is contesting that will bring out your criteria, your certificate to say this is what qualifies me. So if you are disputing his controversial Chicago State University degree, you will be basically making an allegation that that certificate is forged, which is a criminal allegation. And to prove that it is a very tedious task. The courts have been so for me, I think it's a difficult thing to establish. I'm not saying it's impossible, because you will have to go beyond the document itself. Will you be able to subpoena Chicago State University? I have seen some documents on social media where people have quoted the school. Some have said the Chicago have affirmed they have a certain Bola Tinubu or whatever in their record, conflicting information here and there. So how will you now prove that that certificate is forged? Will the university come to Nigeria to testify? That is the problem. Because I keep telling people, and this is why people have the misconception about the legal profession. When you go to the law school or from the faculty of law to the law school and you are called to the bar and you appear in court, you don't necessarily speak to what is true, unfortunately. Because even as the lawyer, I have cases I'm handling now that I can stake my life and say, this is what the truth is. But I don't go to court and say, my Lord, the truth of the matter is that. No. I say, my Lord, the facts before you. The facts before the courts. The evidence before the courts. That is what people capitalize on. And that is why even when sometimes people are on the side of the truth, they still lose cases because they may not have the evidence to substantiate that. That might be the problem with Tinubu's controversial educational qualification. Okay. Regarding the drugs issue, I did explain. If you could just read that 134, please read that 134 D and E again.
Okay, 134.
134. Read that 134.
Says a candidate for an election to the office of president shall be deemed to have been duly elected where there being only 2 candidates for the election. Is that the part you want?
No.
Okay, you want 131 then?
Yes, please. Yes, please.
A person shall be qualified for election to the office of the president.
No, don't just hold on. I'll give you the section I'm looking for. Now,
okay.
Regarding the issue of drugs, right? I explained the other time that it is a delicate matter. Please check what 135, the marginal notes. There's a side note there. I'm looking for disqualification.
Okay, 135, marginal note.
There are marginal notes that explains what the sections are about by the margin.
But tenure of office of president, that's 135.
No, no,
Okay, you are looking for disqualification.
no.
Qualification for election as president.
Yes.
Okay, no, I think it's 137.
Yeah, 137. God bless you.
137.
137.
That's what they call it, marginal notes. Okay, I've learned something.
Yes.
Okay, so why do you want me to read?
Read D and E.
Okay, they say subsection 1 says a person shall not be qualified for election to the office of the president if D says he is under sentence, he's under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed on him by any court or tribunal or substituted by a competent authority for any other sentence imposed on him by such a court or tribunal. Or then E says, within a period of less than 10 years before the date of the election to the office of president, he has been convicted and sentenced for an offense involving dishonesty, or he has been found guilty of the contravention of the code of conduct. Or, you want me to go ahead?
No, it's fine, it's fine.
Okay.
Now, that 137 sub 4 is the basis for the drug case. Because 137E has certain qualifications, including a limitation period that will not favor any action that is premised on it. One of which is that the 10-year period, the action or the complaint must be within 10 years of the conviction or sentence or fine as it relates to the code of conduct. Whereas 137D appears not to have a time limit.
Yeah.
Now, if the Court of Appeal favors that opinion, because look, Tinubu cannot, I made this point. I have been very careful in the way I address issues. I try to be very objective. One of the facts that Tinubu cannot dispute, can never dispute, is that he forfeited monies to the US government on account of his implication, his involvement in the drugs matter that was investigated. Now, he is not going to challenge that fact. What he's going to challenge is the interpretation given to that fact, and two, the consequence of that interpretation. What I mean is that when Tinubu, look, these things, I can predict these things. When Tinubu files his response, his reply, one, they will try to drag, I suspect his lawyers will try to link 137D and 137E regarding the 10-year period. They will try to bring it to marry those provisions. I'm not sure that is going to be accepted. I'm not sure that is going to fly. I'm not sure that the courts will accept that argument. But what I know is that when that argument is made, he is going to say that despite this forfeiture, it does not affect his qualification, because he's going to argue that, one, that was not a conviction. Again, whether the court will accept that argument is a different thing entirely. I'm just preempting what I believe will be their response. But however, I want to see how our courts and our judiciary will approach that issue. So for now, because it is an area that a provision that strictly has not been really tested very much, especially in relation to Tinubu's the facts in Tinubu's case, I think we just have to await, let's even see what they are going to say, what their answer is going to be in reaction to that ground of the petition.
Okay, thank you so much. I think there's a hand that has been here. Motorola, I'm going to allow you to do this, but going forward, if somebody is not properly named, I won't be bringing that person in. So that's how we leave a place where people can actually rename themselves. Putibe, your hand has been up for a very long time. So go ahead, please. Kindly let us know what your name is.
Aisha, God bless you.
Well done, sir.
I'm Samuel Efeturi.
Okay, welcome.
Yes. Thank you very much. I'm going to reserve my comments about you for another day. That's
Absolutely,
not
sir.
for Inibehe. I want to thank you for availing yourself of this opportunity for us to have this discourse. Now, straight to my issue. When you are in a battle, one principle is to fight with everything you have. Don't discount anything. Fight with everything you have. I can assure you that the people in question are not relying only on the logics and the legal interpretations and so on and so forth. They are going in anything that will influence the matter in their favor, one way or the other. So that brings me to my question. Barrister Inibehe, please, can you explain to us the process of coming to a decision at the Tribunal Court and the Supreme Court? The selection of the judges, who are these people? Is there anybody that can influence them, or is it just a decision by one person, the CJN? And having appointed them, what is the process of coming to a decision? Is it by voting by these people? How many of them? 10 of them? Do we know their names? Can their names be divulged to the public? And if not, when they eventually come to a decision, when there's a split in decision, will all of the details of the split and everything be made public? And before it goes to Supreme Court, what are the ways in which we can get involved in? For instance, now, Aisha, I'm sure you remember, Pastor Paul Eneche did a very short something on his message to the CJN. I like that. We need to work on the psyche of these judges, present a new Nigeria to them, because they're human beings like us. Even if we don't know them, I expect that we should be working on making sure that, just like our sister, Nena Oti, there are many of them like that, but we don't know whether they might select such people to fill the panel. But even if they don't, we need to be working on the new Nigerian spirit being passed on, being re-emphasized, being pushed on, because you never can say one man there might be.
Okay, sir. Yeah.
I'm all right with my something? Okay for now?
Yeah,
Right.
I'll need you to round up, please.
Okay. No, it's okay. If my time is over, it's okay. I think I've made my point to an extent.
Okay. Thank you. Thank you very much, sir.
But sorry, Aisha, please, before I go, I need another forum that I can make direct communication with you, because there are so many things I want to say here that I cannot put up in the open. So please.
Okay, it's always the way I spell my name at gmail.com, aishayusufu@gmail.com. That's my email address. So you can always reach me on email, via email.
Okay. I will send
Sorry,
you.
Aisha, yeah.
Okay then. Thank you.
Thank
Comrade,
you.
can I request that one priest, Nwankwo, be removed from this platform?
Yeah, I'm gonna remove him right now. I just wanted to first of all write a response before removing him.
That's Nwankwo. I think it's quite
Charles
responsible.
That's absolutely criminal, and that's not what we are here for. We are law-abiding Nigerians. As if that was exactly what I'm typing.
Well, sir, to respond to your question, what the Constitution says is that at the Court of Appeal, it is the President of the Court of Appeal that will empanel the tribunal, that will determine the persons who are to sit in the panel that is going to hear the petition. I expect about 5 justices. 5 justices traditionally will sit over such matters. At the Court of Appeal, they sit in panels of 3 and 5. 3 for regular cases, 5 for certain special cases, including presidential petitions and matters of serious constitutional significance. Now, it is the president of the Court of Appeal that will impanel them, that will select from his brother justices, those who should form part of the panel that will hear the petition. What I know they do is that when the members of the panel are selected by the president of the Court of Appeal, I don't know whether the president himself will be part of that panel. So in the panel, they have what is called the presiding justice, right? And when they are done with the hearing, they will have a lead judgment and possibly dissenting judgment. Now, the justice who presides is typically the most senior, because the legal system, the legal profession is based on seniority and hierarchy, right? So when the panel is set up, the 5 justices are selected. They based on the preference of the president of the Court of Appeal. Unlike the US, where the courts, the American system, where the courts have ideological leaning. For example, you have the conservative justices, you have the liberal justices. In Nigeria, we don't have that. We don't really have that, really. Of course, we as lawyers in practice, we know that some justices have certain leanings and certain disposition to that are different, but it is not so obvious. It is not so obvious, because you could find, for example, one justice reading the lead judgment in a particular case, and in a different case that have the same characteristics, the same justice may be the one to read the lead judgment that differs from the earlier decision. So we don't really have that strict ideological leaning. We don't have an ideological leaning in our courts. That is not to say that the justices do not have their own preferences or their own disposition to matters. I don't want to be too direct about it, but within the courts, they have their own way of looking at matters. There are some justices that are deemed to be a bit more liberal. There are some that are known to be a bit more conservative. But the liberal and conservative character here is not the American type, right? Mm-hmm. Their leaning, their ideological leaning is not based on, if you file a case that is based on same-sex marriage, or you file a case that is based on the right to vote, or affirmative action, or death sentence, or what have you, you are so certain that this is how this justice is going to rule. No, we don't have that ideology on subject matter. But some justices are, over time, known to take certain approaches to their matters. So when the president of the Court of Appeal sets up that panel, I suspect they will be drawn from different parts of the country, the justices. It's not just justices in the Abuja division. As a matter of fact, even the tribunal itself, I can confirm to you, the registry of the Presidential Election Tribunal, the court officials that are part of that registry, most of them don't even work in the headquarters of the Court of Appeal. I have confirmed that. They were drawn from different divisions within the country, so that also leads to some inaccessibility by people who may want to easily reach out to them. So when they have heard the evidence, they will have what is called a conference, right? It is at that conference that they will discuss the case, the evidence that were adduced, presented before them, and then possibly take a vote, right? And then from there, they will know where each justice stands on the matter. When they have taken the vote, they see the position of the majority. If the majority says that the election should be nullified, right? Now, because the majority here has to be 3, the dissent has to be 2. That is why the the number is odd. It is not even. Even at the Supreme Court, you will have 7. You don't have 6. So that in the event of a tie, there can be no tie. It is either you have 3-2, 4-1, right, or 5/5. Either 5/5, 4/1, or 3-2. Those are the scenarios at the Court of Appeal. When they have now taken that division, if the majority says the election should be nullified, if 3 or 4 or the whole of them say the election should be nullified, they will now choose from among the majority who should write the lead judgment. When the draft of the lead judgment is written, it will now be circulated to all the justices. For what? For what is called a concurrent judgment, right? By law, every justice, every member of the panel is entitled to write his own separate judgment. But there is what is called a leading judgment. That leading judgment is the authoritative position of the court. The concurrent judgment basically solidifies the leading judgment. Now, that leading judgment will also be given to those that are dissenting. And those that are dissenting will now write their own dissenting judgment to say, we have had a preview of reading the draft of the lead judgment read by my brother justice. I do not agree for reasons so and so. All that is going to be pronounced openly, publicly. Everybody will know where his justice stood. Even when the other scenario is that when in the lead, all of them don't need to write lengthy opinions. They could just simply affirm. I have had the privilege of reading the draft of the judgment. The lead judgment just read my brother justice so and so, justice so and so. I agree entirely with the judgment and I abide by the orders made. That is his position. That is his position. So they will all express an opinion either in detail or basically by accepting what the lead judgment has said, or that is going to be what is going to happen. So everybody will know where they stand. So the question of who is going to influence the membership of the panel, that is a decision constitutionally that can only be taken by the heads of courts. And this is not restricted to election petition. It is so in all cases. Even at the high courts, at the federal high courts, right? It is the head of courts, the head of court that basically assigns the cases. At the division, they have what is called the administrative judge, the admin judge, that assigns cases to judges. And at the national level, where you have the chief judge of the federal high court, like in Abuja, that assigns cases, but they usually delegate that power to their second. At the Court of Appeal, at the division, you have the presiding justice in each of the division. At the headquarters, you have the PCJ. You have the president of the Court of Appeal. At the Supreme Court, when the appeal now goes to the Supreme Court, that is when the CJN comes into play. That is the one that really counts, eventually. It is the 7 wise men of the Supreme Court that will determine the fate of this election. One of the things we should push for is to have all justices sit on presidential petition. I don't like the idea of having a panel in a matter that has to do with the fate of the country. We should have the American system we can start with a presidential petition. We cannot have that in all cases because the courts are congested. As I speak to you, you can Google this report by the Punch, Supreme Court of Death cases. Supreme Court of Nigeria, as I speak to you, still has cases that were filed in the 80s before them that they have not determined. It is that bad. Save for these political matters that have a time frame. They are overworked, they are few. If you see the pressure on them, you will understand how difficult it is for them to even arrive at a decision. So you have a situation where they have to sit in panels. But I advocate that for political matters, especially presidential petitions, and possibly governorship appeals coming before them, every justice of the Supreme Court, the Constitution currently says 21. We barely have up to 18. We don't even have a full court now. Every justice of the Supreme Court should be part of it. There should be no process of saying, this is who should sit, this is who should not be. Every single one of them should be part of the panel. But until the law changes, you will have 7 justices
Okay.
chosen by the CJN. And the same process of having conference, writing lead judgment and dissenting judgment, if any, will also be applicable.
Thank you so much, Inibehe. I think that your explanation has explained a lot of questions that some other people have here, because there were people who were asking what is the importance of CJN and all of that. Well, like you rightly said, now he'll be the one to appoint, right? Or choose the 7 justices. Is that the correct?
No, it is the CJN, yes.
Yeah.
Undoubtedly, it is a CJN. There's no room for argument.
Because people were asking what is the importance of the CJN. But before I go on, there's someone who made a request.
The CJN can also nominate himself.
Okay.
If he's part of the panel, which is a possibility, he's going to be the presiding justice. He may not likely be the one that will read the lead judgment, but he will be the one presiding because, I mean, he's the most senior.
So when he comes in, it will not be himself and 6 other people.
Absolutely.
That will be bringing in. Okay. So there's a request that someone has made on YouTube, just a bit of selfie. He said, please, is it possible if you can put off some of those lights that you have up? You know, there are people who are photosensitive, and because they're flashing a little bit so that it might disturb some people. So I saw you have
Yes.
Like,
it was actually to see how, I think I should just change my sitting position.
Yeah, that would be fantastic. Yes.
I was hoping to have, is this better?
Yes, this is much better. Thank you so much for that, because there are some people who are photo sensitive and things like that affect them. Let me just quickly go to, there were some questions also. On the issue of televising, someone has asked, but I don't think that's actually factual. He's saying whether the CJN has made a commitment on that. There is not, but there are people who have been asking for a televised and hearing. I think that's what we really need in this case. But let me just ask you, what is the legality of that? Is that something that citizens can do? And what are the things that citizens can do to ensure that they actually get a live streaming?
I suspect it may happen. Particularly because the NBA has also taken a position to call for that. The NBA has asked that should be done. I suspect it may happen. I know that for judgment, it is usually televised. Those who have followed our elections, even from the other days, they will always televise the judgment. But the day-to-day hearing is what is not certain. But I hope that will be done. I know the courts are, they are aware of the interest that Nigerians have in the process. It will further enhance the credibility of the entire judiciary process if the proceedings are televised. I totally support that.
Okay, and so citizens, please continue to make demands on that, to ask questions on that. So there's also, I'm trying to look at, there's a question I was trying to look at here. Okay, so someone is asking, Fabian Chukuma says, please, I should ask you where the court stand on the issue of entry results saved on IREF as evidence and used in the case, since it has been stated that INEC didn't break the law by using IREF or something. That's what he's saying.
Who said INEC did not break the law? That is not true.
So that's what Fabian Chukwu is.
INEC actually broke the law. INEC has not said it did not break the law.
Okay.
If there is anyone that has evidence or any source, any material, any statement by INEC where they have said they did not break the law on the issue of IREF, let the person share it. You can share the link as a comment. I want to see it.
Okay.
INEC has not said it. Even at the tribunal, that is not going to be the argument. What they will say will be to tell the court the effects that should be given to that breach.
Okay.
They are not going to argue on the breach because by their own guidelines, right? Yeah. I explained the last time that the Electoral Act, if you look at section 60 sub 5, I think you can read it. Section 60 sub 5 of the Electoral Act. Please read it.
Okay. Section 60 is on the counting of votes and forms. 5, it says the presiding officer shall transfer the results, including total number of accredited voters and results of the ballot, in a manner as prescribed by the commission.
So what does that mean? What is the transfer here? That is the transmission.
Yeah, the transmission that they said they were going to do.
He said in a manner as prescribed by the commission.
Yes.
So what the question we should all ask is, what manner did the commission prescribe? And the answer is in their guidelines, paragraph 38.
So let me read also section 6, where it says, a presiding officer who willfully contravenes any provision of this section commits an offense and is liable on conviction to a fine not more than 500,000 or imprisonment for a term of at least 6 months.
Look, this argument that election didn't have to be, that the result did not have to be transferred at the real time, at the polling unit, for me is nonsensical. I mean, I don't respect that opinion until the court rules otherwise. You know why? That sub-6 you just read makes it a criminal offense.
Yeah.
For a presiding officer to default, to willfully refuse to transfer. Now, I explained the process at the first part of this discussion last week. I said that election was not an event. Election is a process.
Yes.
And I took time to explain the processes. Once the process at the polling unit are ended, all that the presiding officer has to do is to go to the registration area, which is the word collation. Once he has arrived at the collation point, the presiding officer's duty has finished. It is not left for the result to be handed over to the collation officers to be collated. So if you don't transfer at the place where your primary assignment is, where you are supposed to carry out your functions, is it now at the point of collation that you will now transfer? Or what is the mode of transmission? Even if, you know, let's say that is not the appropriate way to look at it. What is the mode of transmission, the mode of transfer? INEC clearly said the manner in which the transfer was to be done. Yeah. And they have breached that. They have breached that. So I want to wait and see how the courts will approach this. Whether they will say, yes, truly, the transmission was not done when it was supposed to be done. However, we don't feel that is enough reason to nullify the election. Let the court say so. But for me, the law as of today is clear, and the facts are also clear.
Thank you so much. We have 3 people whose hands are up. I think we take those 3 participants, and then we'll come back to you. What I'll just do is to just write those questions down as they ask them. Please, this time, it's going to be brief. It's going to be 2 minutes each for each participant, and the timer will be on. When you hear when it's 10 seconds to, I will interrupt you and tell you it's 10 seconds remaining. And then when the timer begins to beep, your time is off. If you're mid-sentence, we'll have to cut you off to get to the next person. So I'm going to start with Abiodun Anoluwapo. I hope I got that right. So Abiodun, please kindly unmute yourself and go ahead with either question or comment. You have 2 minutes, and your 2 minutes starts now.
All right, thank you so much. My name is Abiodun Anoluwapo. I only have questions to ask, and the question is that, please, because we all know that even though the UN and other countries are observing these presidential observe these presidential election results, and they are making comments on it. But my question is that, because what I always add and what I've been hearing from people is that this so-called man, Tinubu, is a person that he has the money to spend. And I hope these justices and others will not be also be influenced by his money, because you know that's the first problem we have from INEC. If not because of the money that he has given to the INEC to bribe them, I don't think the INEC should violate the rules and regulations of the Electoral Act. Not to talk of going against what the law says about the election. So, and since this has happened, I hope it will not happen again. I hope the same mistake will not repeat itself. So my own question is that, who are the CJNs that we have that are really fighting? Is there any organization or any like self-organization that is really doing these things purposely for us, for the sake of the citizen, for the sake of this country, or not for the sake of their own pocket? So that's my question. Thank you so much.
Well, that is an extra legal question. All I can tell you is that I don't want to go into the personalities of the members of the court, but what I can tell you is that there is no justice of the Court of Appeal or the Supreme Court who does not live in Nigeria, or who is not a Nigerian, or who does not have family in Nigeria. They know what is going on in the country. They were aware of the process. But when the matter comes before them, they are expected to be unbiased umpire. Now, I think we should just allow the process to unfold. Mm-hmm. Let's even see what will happen during the hearing. Let's see what evidence will be brought. Let's see how far the petitioners would be able to go in proving their cases. And then we can then make an assessment of whatever decision is rendered.
Thank you.
I have had cause a couple of times to disagree with certain decisions of our courts, and I have never been shy about expressing my reservations with decisions taken by our courts where I feel that a different decision could have been reached. But that is all that you can do. You can offer an opinion, and then it is the right to freedom of expression. But for now, let us see what is going to happen during the hearing.
Thank you so much, Inibehe, for that. Please let our questions be focused on the petitions that we have on an issue of legality. When it comes to conspiracy theories, hearsays, and what say, that's not what we should be talking about here. So the questions that we can answer, that he can answer, the issues that have to do with the law. If you say, oh, there has been this and that, if you have evidence to back it up, everything has to be evidence-based. And so that something can be true. And he did mention it here. It's not, but when you go to the court doesn't care whether something is true or not. What the court cares about is, do you have evidence to back what you're saying? So that's what we should focus on. Ebubechukwu, go ahead, please, and unmute yourself. Yeah. You can also put your video on if you want to.
Okay. Can you hear me?
Yes, we can hear you, and your 2 minutes starts now.
All right. My question is, please, will like for the last time I checked, someone told me that there are only about 7 men judges at the Supreme Court bench. So and it's always 12. So my question is, if, for instance, if Ahmed Bola Tinubu was to be, will I say, sworn in, will he be the one to appoint the rest of the judges?
No. That is not possible. That is not, the president does not on his own just arbitrarily appoint
judges.
Justice. Really, constitutionally, it is the Federal Judicial Service Commission and the National Judicial Council, right, that determines who comes and who comes to the bench. They have to make recommendations. The president and governors only act on those recommendations. Mm-hmm. Nobody can become a justice of the Court of Appeal or the Supreme Court. As a matter of fact, today it is by elevation. There is no member of the Supreme Court or the Court of Appeal in Nigeria today that did not come from the bench. The efforts to get members of the bar to be part of our appellate courts have failed. So you have to be at the High Court. You are elevated to the Court of Appeal. From the Court of Appeal, you are elevated to the Supreme Court. And then the process of that elevation is based on recommendation of the Federal Judicial Service Commission and the National Judicial Council. That is how it is done. They only make recommendations. If they don't recommend, the president cannot appoint. And even if when Tinubu, I mean, is sworn in, right? If he's sworn in, even if he appoints other people to go to the bench, they are not going to be part of the tribunal. I mean, I've already explained the process. They are not going to be part of the tribunal because before that time, the tribunal would have already been constituted. So anybody that is going to sit in this matter at the Court of Appeal must have already been a member of the court before 29th of May. And at the Supreme Court, I can guarantee you, it's going to be one of the justices, it's going to be 7 of the justices who are currently members of the court. No new person. There is no scenario that will allow somebody to come from outside and be recently appointed to go to the panel. And even if that were to be done, what effects, I mean, if it is one, what effect will it have on the, you know? And let me also say, to some extent, the courts, the justices have their own individual opinion, right? They are not necessarily detected to by the heads of courts or by the president of the Court of Appeal. You only know because it is a case of primus inter pares, is first among equals. They are all equals, right? They are all justices of the Court of Appeal, except that one is now made the president. It is like what you have in university, where you have a class rep, but your class rep is still a member of your class. He is not above your class, right? Or in secondary school where you have prefects, you have the senior prefect. The senior prefect is still a final year student. He's not going to graduate earlier than the other students, except that in this case, it is based on seniority. Typically, it is the most senior that becomes the president of the Court of Appeal. At the Supreme Court, you can simply look at the order of seniority and they say who the next CJN is going to be, and the one after him. That is the tradition. It is governors who have tried to corrupt that tradition. We have seen that in a couple of states, Cross River, Kwara, and a couple of other states. You know, other than that, the tradition that is established, it is based on seniority that they are appointed. So let's just wait and see.
Thank you so much for that. And I love the angle you just brought in where you said, look, let people understand that even if there's no how that any president, whether newly sworn in or whatever, can change the people who are going to sit at that thing. It's a bit of psychological war that is going on, and a lot of, you know, when the minds of the people, they try to defeat the minds of the people. That if you control the minds of the people, you control everything. So let's just leave all of those things and focus on the court itself and ensure that they do the needful. So you've heard it. There's no how that even if Bola Ahmed Tinubu is sworn in today, that he can just go and bring in lawyers and they are the ones that make up the people that will be judged. No. It's not a possibility at all. These are things that we should go leave out of it. And on the issue of whether there will be a swearing in on May 29th, there's no vacuum. There can't be any vacuum in office, right? And of course, Buhari has to go on May 29th because his tenure expires, and then the next person who gets in there. But that doesn't mean that it's now going to now begin to appoint people into that position. We have Ameze. I think Ameze is the one we were taking in the last round of 3 people that we have. A new hand is up right now. I'll see whether we're able to take that before we go back to the charts. So Ameze Bello Sagi, go on please and unmute yourself.
Hi, good evening. Thank you very much to the panelists for organizing this session. I have 3 quick questions that I'll fit into my 2 minutes. First, I have seen some commentary suggesting that INEC is entitled to a presumption of regularity in court, i.e. that the court is to assume that their conduct was proper until there's compelling evidence otherwise. Is this correct? And if so, what's the legal basis for this? Second question, I have a clarifying question on the leading judgment. How do you determine who joined the leading judgment? So if you have a case where there are 7 justices on the panel, 4 vote for one position, 3 vote the other way, so the 4 are in the majority. There's a leading judgment and let's say 3 concurring judgments. What gives the leading judgment this special status? Is it that the other 3 justices who wrote concurring opinions have also signed off on it or joined it in some formal way? Could you explain that? Then final question, how do Nigerian lawyers source the Supreme Court's opinions? In other countries, obviously, these documents are made publicly available on the internet. So, for example, somebody who wants to research can just download and read. But my understanding is that that's not the case. So where do you get these opinions from? Thank you very much.
Thank you very much. And you left us with 55 seconds extra, and you did ask a lot of questions. So that's what
interesting questions.
Well done. I'm telling you, interesting question in about a minute. Thank you.
Yeah, Aisha, can you go to section 294 of the Constitution? Please confirm what the marginal note says. 294.
294 of the Constitution.
Yeah.
I'm loving this though. Let me come and do this thing in your office. Determination of causes and matters.
Good. Please read. Can you read it? Read the
yes. Okay. Let me quickly. I'm going to read it, but I've just found out that my
in the university. Sorry, at an aside, I had basically all these constitutional things or sections on my head.
Yes, that's the thing. Now they're not applying.
Now we have so many things to.
There are so many things
in our head at the same time. Yeah.
Yes.
Please check 294 sub 1.
Yeah, I'm coming. So what I'm trying to do, okay, you're looking for one, right?
Okay. Yes.
294 subsection 1 says every court established under this constitution shall deliver its decision in writing. No, hold on. You know what I'm holding on? I think I have an older, I'm using my, let me go back to my internet. Sorry, to the E1, so that I know I'm getting the, what's happening?
No, just read. You can just read the entire provision. It's not quite lengthy.
No, it's not lengthy, but I'm just so whether I have the most recent one. That's where my problem is.
It has not been amended.
Oh, okay, that part. Okay.
That provision has not been amended.
Okay, then fantastic. 294 subsection 1 says every court established under this constitution shall deliver its decision in writing not later than 90 days after the conclusion of evidence, and final addresses and furnish all parties to the cause or matter determined with duly authenticated copies of the decision within 7 days of the delivery thereof.
Continue, please.
Subsection 2 says each justice of the Supreme Court.
Please listen to that.
Okay.
Yeah.
It says each justice of the Supreme Court or of the Court of Appeal shall express and deliver his opinion in writing, or may state in writing that he adopts the opinion of any other justice who delivers a written opinion.
So that's that. Yeah. So my sister who just asked 3 questions, I decided to start from your from your second question.
Yeah.
Because it relates to what I had explained earlier. I believe that provision that Aisha has read settles the matter.
Yeah.
Now, you can see from that provision that if they're just in the Supreme Court and the Court of Appeal, the Constitution says they must individually express their opinion. And I explained how that is done. There are 2 ways to do it. Now, when you look for example, in the Oshun judgment that has just been delivered, the 5-member panel of the Court of Appeal, there are 5 decisions. I have them, right? If you want it, I can send it to you so that you can look at it and you will understand this thing. There are 5 opinions that were expressed by the 5 members of the panel, right? Where they individually express their opinion. But that is when, that depends on whether there is a leading judgment or a dissenting judgment, majority or minority judgment. Now, whether it is minority judgment or majority judgment, all of them must express their opinion on where they stand. She asked the question, why is the leading judgment given a special status? Well, what the law says about, there are 2, a judgment can be either leading judgment or concurrent judgment. Concurrence is from concurrence, that is, I agree, to affirm, I align. So what you would, what you have these days, because as I said, they have too many cases to attend to. I'm telling you, the courts are congested. The dockets of the courts are filled. If, in fairness to the judiciary, if you have had a case in Nigerian courts, you will know that our judges work more than most judicial officers in the world. The volume of work, in fact, go to a typical high court. Go to a high court in Ikeja, or Iboshere on Monday, you will see a court that on a given day, they could have 25, 30 cases to attend to in a busy division like Lagos. You could even have up to 30 and more in one day. Some of those cases are for hearing, some for mention, some for report of what was for different, they are adjourned for different things. They still have to write judgments. They still have to review the files. So the workload is much. So at the appellate level, it is the same thing. There are so many cases that come before them, except for special cases like this, that you have a panel, right? When they have heard the evidence, they will go into their chambers and have a conference. These are things you may not read online on social media. This is something I'm telling you that happens in practice. These are things that lawyers may not tell you on TV. But what happens is that when they have listened to the evidence, all of them will retire to their chambers, sit together, right? And then discuss the matter. From that discussion, they could take a vote on where they are going to, the position they want to take. It is also possible that in the leading judgments, the majority judgment and the minority judgment, they could agree on certain, they could have an agreement. But what they would disagree on is the reliefs, whether the petition should succeed or should fail. But regarding some principles, they will agree on certain issues. There are things that cannot be disputed. But the final determination is what they may not agree on. I have a feeling that in this particular election petition, we may not have 5/5. I don't know what, I'm not going to preempt what the outcome will be, whether it will be for or against, but I have a feeling that it may not be 5/5, either for or against. They may likely be majority and minority decision. The leading judgment is important because the leading judgment is usually the more extensive judgment. It is a judgment that speaks to all the issues for determination. It is a judgment that explains the arguments of the parties, the appellants and the respondents, or in this case, the petitioners and the respondents in their briefs, in their addresses, right? It is that judgment that is detailed. So the concurrent judgment basically comes to affirm what the leading judgment says. It cannot differ. But the dissenting judgment or the minority judgment takes a radically different position. Now, Aisha, please, that 294, can you read sub 3? I think there's a sub 3.
Okay. Before I read the 3, there's a sub 3, there's 4, 5, 6.
Yeah, there is one that says that the division of the court shall be the division shall be the opinion of the majority of the members.
Yes. So I just wanted to read that too. There was something they added I had not read earlier. We say, provided that it shall not be necessary for all the justices who heard a cause or matter to be present when judgment is to be delivered, and the opinion of a justice may be pronounced or read by any other justice, whether or not he was present at the hearing.
Yes,
so
I have done matters at the Court of Appeal, where I've done matters, and this is not a story, I'm telling you my own experience. I've done a couple of matters at the Court of Appeal. On the day of the hearing, you have 3 members of the panel. But in those matters, on the day of judgment, it is one that was likely sit. You will not have all the 3. But the important thing is that when you get a copy of the judgment, you'll see the opinion of each of them. Okay. What the law does not allow is a situation where the justices who heard the evidence differs from those who delivered the judgment, or there is a change. If that happens, it becomes very problematic. I can give you several precedents of the Supreme Court where judgments of the Court of Appeal have been set aside on that ground, including the division reverse, on the ground that the members of the panel were changed at the stage of judgment. So in the case of presidential election petition, because of how important it is, the possibility of having a justice, of having less than 5 on the day of judgment is slim, except a member of the panel is ill. Look, this is a national assignment. It's a special, it's not a regular court. They are drawn from different places. So, but please go to that, there's a part of it.
So the subsection 3 says, a decision of a court consisting of more than one judge shall be determined by the opinion of the majority of its members. Should I
that is yeah, that's no, it's okay. That is self-explanatory. So I've answered that question. The other question is on presumption of regularity. Yes, that is correct. That presumption is founded on two pieces of legislation. One is the Evidence Act, two is the Electoral Act. There's a provision in the Evidence Act that gives a presumption of regularity to official acts, people that act in official capacity. It is, however, what we lawyers call, there are two types of presumptions in law anyway. You have rebuttable and irrebuttable presumption, right? You have there are presumptions that are rebuttable. Rebuttable in the sense that when evidence is adduced, that presumption can collapse on the surface, right? When evidence is adduced to the contrary, it's not going to stand. There are, however, presumptions that are irrebuttable. It never changes. It is everlasting. In this case, the presumption of regularity in favor of INEC is a rebuttable presumption that can be negatived by adducing evidence. So I don't know if I have the time to go back to explain in details how that affects the current election. But what INEC does, certain acts of INEC are presumed to be regular. And I have argued, I am not in favor of that principle in our elections because it does not help our jurisprudence. It has only emboldened impunity. It has only emboldened INEC to continue to do what is wrong. INEC should not have that presumption. INEC does not have the moral standing to command that presumption in its favor. Now, of course, it can be rebutted. I mean, it can be rebutted. It is rebuttable when the evidence is there. Now, the other question you ask is, where do lawyers in Nigeria get where can people have access to judgments of court? It's very easy. You don't need to be a lawyer to have access to legal materials in Nigeria or judgments of court. You can simply go to, you can simply go to where law materials are sold, where law reports are sold. Nigerian Weekly Law Reports, they have their offices. You can Google their offices in Lagos here. There's a particular judgment you want to read, but you must know the citation. There's what is called the citation. If you need a particular case, you will need the citation. It is reported into
is it online? Is it online? That's what her question is. How easy is it?
Yeah, I'm coming to that. Law reports in Nigeria are in two forms. You have the hard copy law reports, you have the electronic law reports. In my laptop here, I have what is called the Law Pavilion. That is the most prominent. In fact, that is the most popular law report. Now, I can simply sit in my laptop that I have before you. I have what is called the Law Pavilion, and they have a live subscription. It's about their premium is about 150,000 or so. When you subscribe, you have access to thousands and thousands of judgments of Nigerian courts from as far back as you can imagine. But if you are not a lawyer, what interest will you have to go and subscribe to that? Other than that, you have the Federation Weekly Law Reports that also have an online platform. You can easily access, pay for a particular report and have access to it. They are accessible, but I believe they can be more accessible. In the US, for example, immediately the judgment is delivered by their courts. You go on the website and you download it. Nigeria has tried to do that at the industrial court level. If you go to the website of the National Industrial Court, you will see their judgments there. At the High Court stage, it's not really quite strong. The Supreme Court does not have that. The Court of Appeal does not have that. It is one of the things that we should be advocating for, digitalization of our courts. So these laws are accessible, but let me advise, I would have said caution, but let me advise. Forget that the pride that lawyers want to have about their profession. When you are reading the law, you are reading the law as someone that is educated. You are reading English, and you will understand it based on the English that is used in writing it, the judgment. But a lawyer is not just looking at the English by which the law is expressed. The difference between one that is legally trained and one that does not have that training is how it affects the meaning of what you have read. It's a different thing entirely. It's a different thing entirely. For example, some of these provisions I have cited to ask Aisha to read, for you to understand those provisions, you may need to look at another provision. So these things are a bit technical, but for the regular things like the Constitution is available online. If you Google the Constitution, you will see it. The Electoral Act is available. The INEC guidelines, all these materials are available on the internet. You can download them and read it and you can make sense of them. They are not too complicated for one to make meaning of, except the ones that are just technical in nature. I believe I've touched on the 3 questions. Aisha, are you there?
Yes, I'm here. I'm here, please. So there are quite a number of questions that have been coming in. Some of them have already been answered. So please, I will jump your question if it's already been spoken about. Okay, they've talked about the. Okay, the questions here you've touched on all of, but there's one we say if the Court of Appeal nullifies the election before swearing in, what will be the next course of action?
Tinubu will remain in office until the Supreme Court rules otherwise.
Okay.
That is what the Electoral Act says.
I had sent a message to someone. I don't know if it's saying it. Benga Oduniyi, I sent a direct message to you. Please kindly read it and let me know. Okay, somebody, Felix Dikbo, to everyone says, in your opinion as a learned jurist, do you think the OB team has a good case? Yeah, that's one question. I don't know if it's a question you are able to answer.
My personal opinion, yes, they do.
Okay, so you've heard that, Felix. So, okay, I'm just trying to quickly go through.
And what is a good case? To a lawyer may not
be
a good
fantastic. So I think it's
a non-lawyer.
that one. Yeah.
When a lawyer says that the case is good, he's saying that the case is arguable. He's saying that there are substantial issues of law to be tried. He's saying that there are issues that are cogent and germane. Right? He's not speaking to resolution or outcome. When a lawyer says that a case is good, ethically, lawyer is not telling you that that this is 100% how the outcome is going, what the outcome would be. All he's simply saying is that there is a case that is worth taking to the court. There are issues that are worth litigating. There are cases that people file that on the face of it, you will know that these ones are destined to fail. But that is not Obi's petition. Obi's case is not, that is not the destiny of the petition. The petition has raised arguable issues of law. They have raised tribal issues. They have raised substantial issues of law that warrants a response from the other parties and that have to be settled by the courts.
Thank you so much. There's a question here from Gloria. Yeah, it's not a question that has to do with what we are discussing right now. So when we get to that place and we bring in guests that will take that, or we take that question. Okay, so I have some hands that are up. Yemi A, her hand is up. So go ahead, please. Kindly unmute yourself.
I just did. Thank you, sis. Good evening, everyone.
I didn't know. I was hello, sis.
Hello, my darling. How now?
I'm fine. Well done. Love you. Yeah, go ahead.
Thanks for doing this. So, Inibehe, I don't think you heard the question. How are you, Jai? Thanks, Inibehe, for Thursday again.
Well done.
Aisha had asked, if the election is annulled, you said Tinubu still remains president-elect?
He remains in office until the Supreme Court takes a decision.
No. She said before swearing in. So he's not in office.
No, he's not going to be annulled. They will not reach a decision before swearing in. I can tell you that for free.
Exactly.
It is impossible. And let me tell you why it is impossible. So that when, like I said, people should moderate their expectations. Some of the things we see on social media are just funny things. I explained that by law, if you look at the first schedule to the Electoral Act, I can direct Aisha to read it if she has the amended version of the Act. You will see that the respondent has 21 days from the date of service of the petition to file his reply. As I speak to you, it is just until recently that they were able to serve Tinubu by substituted means. And their time to respond is still running. You cannot deprive them of that. When they have filed their reply, the petitioners, PDP and Peter Obi, will also file their own answer to what INEC and APC and Asiwaju are filing. If you subtract the time for the pleadings to be concluded for pre-hearing session to commence. At the first part of this discussion, I explained that there is what is called a pre-hearing session. That is why if you look at the application that they filed for leave to inspect materials, election documents, and also obtain CTC, you would have seen that the first relief, by relief I mean the prayer, the first thing they sought was the leave to bring that application outside pre-hearing session. Because under the Electoral Act, every application for the tribunal must be brought during the pre-hearing session. Now, for you, even in that pre-hearing session will take place when pleadings are closed. Everybody has filed what they are supposed to file. And then they will now set a time. The panel will now set a date and for the petitioner to prove his case. And when that is done, they will now, the respondents will also, INEC and the APC will also call their witnesses, tender their documents, and the judgment will be entered. They have 180 days, mind you. Section 285.
6 months,
as
yeah.
amended. They have
So
180
that's
days.
Tribunal. And then if anything.
That is how many months?
That's 6 months.
6 months. They have 6 months.
Yeah. And then after that, if anything, they go to Supreme Court.
Yeah, they will go to the Supreme Court.
Exactly.
Whoever wins or loses, this will end at the Supreme Court. That is guaranteed.
No, I'm just saying, Inibehe, I'm just saying so that for clarity, because I asked the question because you didn't answer what Aisha asked.
Yes.
So you're explaining now that if it cannot be nullified before swearing in, number one. Number two, to even show how long it's going to take, after they had 21 days, Peter Obi filed on the 21st day. Then Tinubu has 21 days from when he was served, and he just got served. So his time just starts counting. Yeah. And when that is done, you have 180 days at the tribunal court that you're saying. And then if anybody appeals, it then still goes to the Supreme Court, right?
No, the 180 days begin to run from the date the petition is filed.
Okay, from the day Peter filed.
Yeah, so it is already counting.
Okay, all right.
The truth is that even I am representing a senatorial candidate of Labour Party in Akwa Ibom at the tribunal. I was only able to file our petition on the 21st day, on the last day. It is not an easy thing to do. What I advocate prospectively is that going forward, that is, and I think, Yemi, I'm happy you are here, so that part of our advocacy regarding the next set of constitutional amendments should be to have all electoral disputes resolved before swearing in. Yeah. I don't think it makes more sense. Yeah. It will aid the credibility of the process, because when you have somebody who is at a tribunal sitting as an incumbent, it is not even the
scale of power.
The scale of justice is not really even.
Yeah, that's very true. Yeah,
because these are extrajudicial or extra-legal issues. But the truth of the matter is that as an incumbent, you have several leverages. I may not speak in detail about this. You have several leverages. That is why people have this anxiety that if Asiwaju becomes president, what is going to happen, what is not going to happen. That also applies to governorships too.
Everybody. Because it's also, I mean, more fundamentally, it's a waste of money. Because you go through the song and dance, you've inaugurated the person has moved into their house, they've set up shop. It's for, I mean, and we've seen it in cases in Ghana and Kenya, where also you now start talking about stability of the country, yada, 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 so that you don't change too many things. And then it now influences how the judges give judgment because they're trying to keep the country one or whatever the language is. So to your point, that's So two things I'd like to add to that really quickly. I mean, I joined when you were talking about all these things about reading and all that. I mean, all of us are suddenly supposed to become lawyers because it's a lot of work. And all of us have full-time jobs. We cannot be reading documents, reading judgments, reading this, reading that. Like, what would you advocate? And I see you smiling. Yes, there's social media rubbish because people just take one piece of news and go to town. And then there's understanding so we can have intelligent conversations. But it's also quite honestly a lot of work. And I'm not paid to be a lawyer. So what would you advise in terms of just helping citizens understand the issue so we, as you said, manage expectations?
One is to monitor the process. In fact, the most important is to have a live transmission of the proceedings. That will go a long way. Because by the time you wake up in the morning and you simply tune into a channel that is, you simply go online and you can watch the proceedings. That will reduce the explanation that lawyers will have to offer or that technical people will have to give you. The other one is to digitalize our judicial system, right? So that these things can be easily managed, these things can be easily accessible. Currently, our judicial system is very far from digitalization. I mean, judges still write with long hands. Judges still write with long hands. Quite regrettably, judges in our court still write with long hands. I cannot be a judge. I cannot be a judge. I function better when I'm on my system typing, right? I can sit on my system and type a 100-page document, but if you ask me to use pen and paper and write 50 pages, it's not an easy, I may not be able to do that. I don't like writing very long, but I can just type. But judges still have to write, except for few courts that they have stereographers and they have been able to acquire these machines. Many of them use their personal money to do that. So these things have to stop, because when you digitalize the courts, the introduction of technology in our courts will aid citizen understanding of the judicial system. It will make the process more transparent. People can easily relate to it. There is so much complication in our legal system.
If we don't follow, yeah, I know. I'm just saying, okay, so one is to follow. I mean, but to be honest, even if you follow it, it's a lot in terms of just keeping track. But are there any, I mean, NBA, for example, is offering free legal service to INEC. Is there any organization or group of lawyers that might be willing to invest that for the benefit of Nigerians? Basically, be doing a cliff notes every morning. This is what happened yesterday. This is your summary to help our lives.
It is something I would have loved to do, but I'm not part of the tribunal. I'm not part of the petition. But,
no, but general, I'm not talking about the B zone in particular. No, I'm just talking generally. I mean, you just said now you're representing a client in Akwa Ibom. So there are many tribunals going on that different people are interested in. So I'm wondering if it's something that could be put to maybe, so Akwa Ibom, for example, will be NBA Akwa Ibom branch or maybe an organization in Akwa Ibom. Is it something that's possible?
NBA will not want to dare to do that. NBA will not do that. What you can have, what is practicable, is to get lawyers who are, you see, the other part is objectivity, right? It is also important to have people that are objective about these issues.
Yes.
To give an opinion, so that they are not necessarily influenced by where they stand in the case. They can give an objective assessment of what is happening.
So why do you think we can get that?
Well, it is possible. It depends on what the area of interest is. Like the election petition, someone has to be at the Court of Appeal every morning, every day that the matter is coming up, to watch the proceedings and then, give a written summary of what transpired. It is a lot of work. A lot of logistics will be required for that to be done.
Right.
But it is not so difficult. It is not so difficult. Of course, the media is going to be there. The journalists will be there. Part of the problem, and I have made this point in several meetings I've had with media executives and journalists in the country, that they don't really train their judicial reporters on judicial reporting. So you have a situation where a journalist can simply just go and write a report that relates to the court or the legal system without even understanding the basics, right?
So I hope I asked about lawyers. Yeah, I think it's key to actually have lawyer. I mean, so there's one thing to be a journalist reporting. There's also another to be a lawyer that understands and is objective. All right, thank you. I think it's to find CSOs that have the capacity to deploy people to observe the proceedings.
It's to look for NGOs that CSOs that will be willing, that have the machinery to do that.
Okay.
To do that. Okay. Thank you very much.
Thank you so much, Yemi. And I think so that's a discussion that I think needs to really be taken on, because citizens are really interested in the judgment and the petitions and everything. And it would be a good thing to be able to keep their interest on, and for also all of us to be more focused on the judiciary system. Well done. Thank you. I'm going to go to Chinonso. Yeah, Chinonso, please unmute yourself. And then after Chinonso, I will come to Akala, Orikolade Akala. Chinonso, go ahead, please.
Yeah, thank you very much, Aisha. And then thank you very much to Mr. Effiong. Please, I have those two questions I wanted to ask. Though I just had to put them through in writing, but let me be vocal too about it. Number one, I wanted to ask, what happens if a respondent fails to file his response within the stipulated time frame? You understand? And number two, I am made to understand that the judge or the jury is a combination of about 6 to 7 man panel, and then their judgment comes based on opinion. Now, I want to ask, is there a form of scrutiny, or investigation as per their opinions? Because anybody can be compromised, or anybody who is compromised could just come up with any opinion after the whole legal drama. So I'm just trying to ask, is there any form of scrutiny as regards the opinion of the juries or the judges before the judgment is being read? Thank you very much.
Thank you so much, Chinonso.
Well, regarding the first question, they have 21 days. The Electoral Act allows for extension of time, but that is hardly granted. In election petition, time is of the essence, right? Because the Constitution has a time frame for filing a petition. It does not have a time frame for filing a reply to a petition. Where you find the time frame is in the Electoral Act, right? And if you look at the Act, if you go to the Electoral Act and check paragraph 21 of the first schedule to the Electoral Act, you see the time frame.
What?
Of the first schedule, that is the last. If you go after the Act itself.
Where it's talking about notice of hearing.
Exactly. If you check paragraph 21.
You want me to read it?
Well, if you have the time. Okay, that is for, no, hold on. That is for, hold on, please. So if you look at the stages, paragraph 12, not 21, paragraph 12, you see that the petition, that the respondent has 21 days. It can be extended, but it's going to be hard. That they will file within time. I can tell you. They will file, they will not take that risk. They will file within time.
It's a risk not worth taking.
They will file within time.
Okay.
Is there a way to scrutinize the judgment before it is read? No, you are not going to know about it.
So that comes to, let me just quickly put in a question that I think is similar towards this area from YouTube, where someone is saying, what if there's a situation whereby a judge is not neutral, is predisposed to a particular party or not?
You can ask the judge to recuse.
Okay.
But, Aisha, you remember what I said the last time here?
Yeah.
Very few lawyers in Nigeria have the courage to to ask to bring that kind of application. The last time I did it, I spent 1 month in prison.
In prison, yes, you did say that.
Most judges, most lawyers in Nigeria will not even look at your face. If you are, I hear people say all sorts of things about the CJ.
Yeah.
You want to ask the Chief Justice of Nigeria to recuse? I'm not saying, look, I'm not saying it's not possible, but your facts must be solid. When if the close, the facts, what happened during the days of F.R.A. Williams? F.R.A. Williams had a case at the Supreme Court where the Supreme Court justices were accused of receiving vehicle from the military government. An article was published. The case that went to the Supreme Court, and then the Supreme Court justices were asked to recuse. Gani Fawemi was involved in that case. And because majority of them had personal direct involvement in that matter, there was no longer a panel to sit on the matter. That was how the case died. But that was in those days. So if you come now and say you want to bring an application for recusal, the facts must be solid. And I kid you not, even when you have the facts, a lawyer will be very careful to tread that path. You know the danger in it? You can irritate the other members of the panel. If the allegation is flimsy, you can really, really irritate them. The last thing you want as the lawyer is to irritate a judge. Once you have irritated a judge, you have given them the impression that you want to challenge them. They will be waiting for you to come. So I don't think we should focus on that. But if you have a reason to believe that a member of the panel is truly biased, You can bring it up. It is something that can be taken up. If the facts are there, the evidence is there, the lawyers may file that application. They can, I mean, I've seen that in tribunal. In election, it has actually happened. There have been examples where members of the panel have been removed. You can write, the other option is you can write to the president of the Court of Appeal to change or remove somebody from the panel. But you must have your facts, please. Have your facts. Don't go and make and it is even easy if it is a member, maybe a justice. If it is the head of the court, my brother, that is I don't know which lawyer will want to take that risk again in Nigeria. It is not an easy thing to do.
The cost is too much. I think there's also a question of what if they don't respond within the time. You've already answered that question, right?
No, I believe they will. I don't see a scenario where they don't file their reply within.
So let's say there's a scenario. So that's the question. Now let's say there's a scenario and the person doesn't file. What normally will happen?
What I can guarantee
continue with the
What I can guarantee you is that the petitions will be determined within 180 days. Have you read what happened in Rivers today, where police arrested? This country is a funny place. Went to raided a hotel, arrested lawyers who were preparing petitions to file for APC candidates in the Rivers election, that House of Assembly election that was just held. They arrested about 3 lawyers with their laptops and their documents they got from INEC while preparing their petition. You know the problem? If for any reason they still hold them to ransom and don't release them, and the 21 days pass, this cannot be extended. Supreme Court said it is like the rock of Gibraltar. It is like Mount Zion that cannot be moved. There is no circumstance under the earth that can alter that time. If you don't determine it, I can cite precedents for you, including the there's a case that arose from Imo State, where Okorocha and I think PDP, where the petition was not determined within 180. That was at the Court of Appeal within 60 days. It automatically lapses. Once one day has passed, that is the end of the matter.
Okay, so Mr. Inibehe, just take us in as lay people that we are. So let's assume that has happened. So the person, there's no response. So will the judgment still continue with the
petition? Yes, the petition, if they don't file a reply, the petition will be deemed uncontested.
Okay. Hey, I think that's the thing that the
petitioners still have to call their case, prove their case. They still have to call witnesses. The only advantage is that whatever evidence they present, there will be no opportunity to rebut it.
Okay. So I think that's basically what people want to hear. Going back now to Mr. Akala, Orikolade Akala, go ahead, please, and unmute yourself, and let's have what your question is or your comment.
Hello, good evening, ma. My name is Orikolade Akala. Good evening to our lawyer there. My question is simple.
Are you able to put on your video?
Yes, but I'm in the vehicle, so. Okay,
no, if you can't, no problem. Go ahead.
So my question is the case between Akeredolu and the PDP concerning that went up to Supreme Court? There's a lower judgment that states they should have bring Buni into it, like the matter of APC. The person who conducted the primaries was Buni, who is a sitting governor, and he has no right to also chair any other thing apart from being governor. So what happens if another party brings this matter to court in this same election that states Buni was the one who organized APC's convention, which he doesn't have the right, while the convention now organized the ones who organized for APC. So in that matter, what will happen?
No, it is a dead matter. Number one, it is a pre-election matter. By section 285 of the Constitution, pre-election matter must be filed within 14 days. Number two, the courts have already ruled on that matter. I was at the Federal High Court. I'm trying to remember the name of the judge. I was at the Federal High Court the day judgment was delivered on that matter, where Buni was sued. I'm aware of judgment of the court on that. And who is doing Wahala? Please don't bring
let me mute there. I forgot to mute. I normally mute immediately after.
Please don't bring spirit of portable here.
I
That
do.
was on a lighter note. I'm aware the courts have already ruled on the matter. That is aside the fact that it is pre-election, and the position the courts took, which I agree with, is that when they filed those cases, some candidates took the APC to court to nullify the primaries on the basis that Buni could not have been the acting national chairman and a governor. That will amount to holding two dual positions, contrary to the constitution. The courts basically dismissed those cases on technical grounds and on substantive grounds. On technical grounds, I'm telling you that I was there the day the judgment was read. I had a different relation matter I was doing at the Federal High Court. The court said Buni could not be sued because by virtue of section 308, he enjoys immunity. So you cannot sue Buni. You cannot have the name of a governor in a court process. So that was already a problem. The other issue is that the court was the internal affair of the party. So it is, and the Supreme Court has ruled.
Barrister, can you hear us?
Al-Hadan's case, Mama Taraba's case, right? That the Supreme Court has ruled that such issues is the domestic affair of the party. Labour Party and PDP have no business with that. And I know nobody can bring that kind of matter now. Any lawyer that files that kind of case is going to have maybe costs that wanted against him or her. The time for that has passed, 14 days. It was pre-election, and then the courts have already ruled on that issue. So that is my answer.
Thank you so much. Ekene, if you have a question, put it out. You just said, Aisha, I have a question. You've not said anything, or else you also raise a hand. Okay, your hand is already raised. Okay, so go ahead and unmute yourself.
Okay. Am I on mute now? Okay.
Yeah, you are. If you also put on your video, that would be good.
Okay, I'm in the dark place.
Okay, it's
so
okay if you can't put it on. Go ahead.
Okay. Thank you very much for this enlightening program. I watched the last Saturday and the barrister, Ini. Thanks for enlightening us. So my question is this 180 days, is it inclusive of apparent Supreme Court decision, or is it just limited to the Federal High Court that serves as the appeal tribunal, appeal court that serves as a tribunal? Is it limited to the tribunal, or is it inclusive of anticipated Supreme Court ruling in the matter as well?
No, 180 days for the tribunal or court, 60 days for the appeals. Supreme Court will have 60 days. 60 days. The Court of Appeal, which sits as tribunal for presidential election petition, is 180 days. Actually, you can read section 285. But for the appeal at the Supreme Court, 60 days from the date the appeal is filed.
Okay. So are you describing 3 stages now instead of 2?
No, there are 2 stages for presidential election petition. At the gubernatorial level, it is 3.
Okay,
that is
I know that.
Governorship, National Assembly. For governorship, it is 3. For National Assembly and House of Assembly, it is 2. It terminates at the Court of Appeal. But for gubernatorial petitions, you have the Governorship Election Tribunal, you have the Court of Appeal, you have the Supreme Court. For the presidential election, you have the Court of Appeal and the Supreme Court.
Okay.
So in other words, the 180 days is a combination of whatever will happen in the tribunal and the Supreme Court.
No. I've already explained that. The 180 days is for the Court of Appeal.
Okay.
Yeah, 60 days for the Supreme Court, independent of the 180 days.
Okay, so it's 160 days and potentially another.
So you are looking at 8 months. You are looking at 8 months.
8 months in all. Okay.
It will not last that long. The good thing about this season of election petition is that there's a new provision of the Electoral Act, I'm trying to recall the section, that has basically reduced the work of the petitioners. We say that if there are facts that they can establish by documents, you don't need to call witnesses. You don't necessarily have to call many witnesses to do that. Before now, if you want to raise the issue of disenfranchisement, for example, you have voting. You have to call witness polling unit by polling unit. It was a monstrosity. Those precedents were like a monstrosity to petitioners because it was impossible to call a witness from polling units all over the country. It was impossible. You can't call thousands of people. How many days do you even have to prove your case? Tribunal sits to 8 p.m. It is a very tedious work. So the time it was almost impossible. The truth of it is that the courts have been asking petitioners to do the impossible, and I have expressed these views different times, both in legal circles and outside, that we need to amend our laws. The West panel would have addressed some of these things. Start with shifting the burden of proof to INEC.
Of course.
Let it be the duty of INEC to prove that
what they did is
they
right.
conducted the election in substantial compliance with the law.
Yeah.
They will sit up. If
I
INEC
agree.
knew that the burden of proof is on them, nobody would have had any debate about not uploading results to IRF because they would have known what the consequence would be. But now, the burden of proof is on the petitioner.
I think it was deliberately done to assist the riggers. This is our constitution is a scam. Thank you.
Thank you so much, Mr. Ekene. Whether the constitution is not a scam or not, is the constitution that we have.
Aisha, sorry, let me tell you another hard thing that you will not read on social media. Another difficult thing about election petition, before this provision of the Electoral Act that I just mentioned, I will get the provision. There's what is called the principle of dumping of documents. So you see all these thousands of documents that Peter Obi and Atiku have obtained. They will tender those documents. The court will not act on them. The court will simply say you dump the documents on them. Do you know what they mean? What that means is that they will tell you you have not demonstrated that document. So you don't just tender exhibits or documents in the court. You have to demonstrate it. In other words, you have to call people on the stand to speak to the contents. That is impossible in an election petition. It is impossible where you have thousands of documents. So the National Assembly, of all the evils, the satanic provisions that they have introduced in the new act, one of the ones they have introduced that is really good is the one that has now said that if it is possible to prove certain facts by documents, you can simply tender those documents implicitly. And then they should be acted upon. I believe that is the meaning that should be given to them. Because before now, you must call witnesses. I'm telling you, you must call witnesses. And it is not possible, it is not achievable. It is not achievable. That is why people keep taunting people go to court. Beyond the issue of lack of confidence in the courts or compromising the courts, part of the confidence that people that are declared have in taunting you to go to court is that they know the legal landmines that you are going to encounter to prove your case. And God have mercy on you, you read allegations that are criminal in nature, like issue of forgery of certificates. That is not an easy mountain to climb. It's not an easy mountain.
Thank you so much, our teacher. So there has been if I can call on Dudu, please kindly help us go through and see what questions are there that we've not answered. And let's get it out. Someone is asking, will the respondent's response to the petition be made available to the public?
I believe so.
Okay.
There is no reason to hide it. It will be made public.
Okay.
It will come out one way or the other, either directly or indirectly. We will get it. If they don't release it to us, we will apply for it and make it available.
Okay, so you get that. Let me just quickly see. There's a question that one has asked on the issue that why was it? Let me get that question. It keeps just going. He's talking about is it the David Leon's case that was done before swearing in? He said, how was that possible?
Pre-election matter. Pre-election matter.
Okay, it was a pre-election matter that now annulled the whole thing.
There are two types of matters. You have what is called pre-election. You have pre-election matters, and you have post-election, which is election petition.
Mm.
The De Villion's case, that is the Bayelsa case now.
Yes, or on the his running mate.
Yeah,
right?
That is not having defective. It was based on documents particularly submitted to INEC.
Okay.
You know, if you remember in the last discussion, I said one of the demonic things the National Assembly did in the 2022 Act was to extinguish two fundamental rights that were given to Nigerians, or two fundamental things from the Electoral Act, which is quite unfortunate. One of which was that under the 2010 Electoral Act that amended, every person in Nigeria had the right to go to court to challenge particulars submitted to INEC. If someone wants to represent my constituency and is giving false information to INEC, the law says I have the right as a citizen to go to court. But now that right has been taken away. It is only available to aspirants who take part in primaries. The second is that there were four extant grounds for challenging an election, including exclusion, where a party has validly nominated a candidate, but INEC excludes that party from the election. That is, exclusion here means the logo of the party does not appear on the ballot paper. That is no longer part of the ground. Again, I believe that is a serious constitutional issue that if it's arriving in court, I want to see how the court will address that. But if you look at section 134 on grounds for presenting an election petition, exclusion is not one of them. That is quite frightening, because I don't understand how whether it was an error on their part or just mischief.
Well, I think, so just like what I was saying when I think it was Mr. Kene that talked about the Constitution, I think one of the things we must understand is that the legislative arm of government is actually a very important arm of government, and unfortunately, most times we overlook them. They are the ones who make the laws. And if you want to have a good Constitution, if we have to have good laws, we need to ensure that people who are going into the legislative arm of government are people with competence, character, and capacity, and are patriotic, and would do the needful for Nigeria. So we must put our attentions there. The laws can actually be changed with or without the president's consent. They can, even if it doesn't assent to the law or whatever it is, they have their two-third power that they can use. So that's very important. Let's also focus on the legislative arm of government and the process of bringing them in. There are a lot of elections that will be going on, by-elections and all of that. It's very important for citizens to look at all over the country, wherever there's any by-election, into the state houses of assembly or the National Assembly. Let's put our effort in there and ensure that people with competence, character, capacity are the ones who get into office. There are questions that are coming up here. So someone says, how can NGOs or private citizens help to bring justice to the following? 1, government officials caught on video committing electoral fraud or electoral offenses. 2, the people that spoke against people from certain ethnic group caught on camera. How can we come in to enforce the laws that the people in government refuse to prosecute? I don't know whether it's something you are able to.
It can be done. I recommend that political parties should be at the forefront of this. They have a stronger legal basis, local standard to address those issues. Okay. But if you go to court as a private citizen, the court will ask you what your interest is. I've been a victim of this. Right? You go to court and they'll tell you you're a busybody. If your interest more than that of other Nigerians, people should begin to. The problem we have in Nigeria is that, one, the institutions are weak and inefficient. The other reason is that even when the institutional processes are there, people seldom activate them. For example, there are videos where people have been caught committing electoral offenses under the Electoral Act. Making campaign on the basis of ethnicity or inciting ethnic or religious disharmony is actually an offense under the Electoral Act.
Yeah.
The prosecutorial power lies in INEC. But the investigative power is that of the police. The police is supposed to investigate, transmit the file to INEC. Because INEC does not have power. INEC is not going to arrest anybody. Under the law, it is the police. So you have a situation where you could have a willing prosecutor and an unwilling investigator. I don't know if you get what I'm saying. Mm-hmm. Now, the NBA has offered to prosecute all those indicted for electoral offenses. It is a good thing. I support it. But INEC must be ready to have that prosecution. The police must also be ready. In Lagos, for example, when you have the first public relations officer saying that James Olomo was joking, you know, he was just doing to tinkle bell, those children play. It was not serious. You see that already at the apex, the police is compromised. When you have the Commissioner of Police of Lagos going on TV to say, oh, that violence in Lagos, disenfranchisement was isolated, it was just 1 or 2 polling units, you already see that the police has lost credibility on the matter. Yeah. That is the challenge we face. But what can we do? Write a petition. What I always advocate, the way I fight government is that even when I know government will not act, I will still document their inaction. Okay. Write to them. Like the James Olomo thing, I had to call on Labour Party to present an official petition. And luckily, within 24 hours after I had read that issue, they wrote an official petition to the SSS and the police. That is documented. If they now they still refuse to act on it, you can file an application for judicial review, seeking an order of mandamus to compel them to do so, right? An order of mandamus. I think this is the area that CSOs can also come in. Civil society should go to court, and victims too. They should be able to go to court to seek an order of mandamus to compel investigation. Gani Forami was filed for an order of mandamus to compel the police to investigate Asiwaju for perjury. I have also filed application for mandamus in a couple of matters, especially FOI-related matters. So there are actually things that can be done within the law. But first is document the misconduct. Beyond social media, write a petition, submit the evidence. When you submit the evidence, they refuse to act, you file an action to compel them to investigate and prosecute. Okay. There is also the allowance for private prosecution, but that is a tricky area because it may not really help here. It is easier in the north, where you have the first information report system, where as a private citizen, you can easily initiate investigation because they have this first information report thing, an inquiry sort of that is done before the actual prosecution. That in the south, it is more difficult. But let the processes be activated. If there are conduct that were purely criminal and people suffer damages, they should be able to sue for damages. Sue for damages. We must act. People say the courts are bad, but have you even activated the court system? Exactly. Have you activated the court system? Before you accuse a judge of being corrupt, being biased, have you even gone before the judge? Yeah, exactly. Nigerians must learn how. One of the things I have seen today is that Sarah is going to court to challenge the federal government, NBC's fine of 5 million on channels. And I said, why is channels not the one going to court? Why do they have to wait for Sarah? No single media house, and I've challenged them at different fora. This is like outside our discussion, but it is important so that we will understand how by our own act of omission, we also encourage this impunity. Because the Channels TV fine arose from a discussion that had to do with the election, the dirty interview. Now, the NBC says Channels TV should pay 5 million. Why has Channels TV not challenged NBC in court? Yeah. When Nigeria Info was fined and asked to pay a fine, the same fine, I was the one who filed an action at the Federal High Court in Lagos to challenge the power of the NBC and the federal government. You know what the judge told me? They just said I'm a busy body. That I don't have the locals, and I am not Nigeria Info. I am not the broadcast station. Why am I the one that is coming? They refuse to indulge the matter. Even when I reach out to the station through some people to give me the document that the NBC wrote to you, they refuse. So why do we keep outsourcing our responsibilities? Those who are direct victims
No, I would tell you why. I would tell you it's fear. So that's one of the things that we have in Nigeria. When either businesses, government has a lot of control in our country, unfortunately, and so they have control over these businesses, individuals, and all of that. And so people are unable to come out and sue. What will normally happen is that you find out that the media will not stop inviting that particular person. So it's a way, it's high-handed. So, and we still don't have people who are, like you mentioned the fact that you can't see any lawyer trying to ask anybody at the Supreme Court to excuse themselves or anything. It's the same thing here. Because so they're afraid their licenses will not be taken away, and most people don't dare. I've had a situation like this before, and I think it was on AIT, where I had made my comment, and then they find immediately NBC sent in this thing, and I'm like, what they simply did was to sort of like have a, is it a blanket rule, or how do they, when you are blacklisted, yes, that's the word, sort of like blacklisted, they don't call you for interviews again, they just try to run away from you and stuff like that. And for someone like me, I'm like, luckily, social media has democratized media. I don't need to be in the face of on any TV set. I just stay in my house and I do my video and I put it out there and it goes where it needs to go. But those are the things that we're dealing with. But hopefully, as we go on and the rule of law begins to be more sacrosanct in our country, all of these things will be things that will be done away with. To quickly come to questions that have also been sent in here. Someone says, I want to ask our lawyer in the house, is it possible for an NGO or individuals to sue INEC for the following? So this one is not in suing INEC. Its failure before and during the election that disenfranchised some citizens as their PVCs were dumped in several places, which INEC must be held responsible for. And then 2, he says, the deliberate failure to use beavers for the presidential election. Is it still also, do they have the local standard to be able to do this?
On the issue of beavers, it is a matter for the candidates and the parties who took part in the election to canvass. That is my position. I think that is being done. I can tell you for the petition that I'm handling, that is very central to our case. And what we simply did was to demonstrate the time and the date of the upload on IREF in every polling unit in the senatorial district, every single one of them. I particularized them. So I have made it an issue. I want to see what the court is going to say about it. I also know that for the other petitions, the same thing would be done. That is a matter for, allow the tribunals to handle that. But regarding the other aspect of misconduct by INEC, INEC should be sued. I mean, I believe INEC should be sued. On the issue of disenfranchisement, however, how are you going to prove that you were disenfranchised? How will you show that you did not vote on the day of the election? Why?
Okay,
You have to bring the
PVC.
voters register. No, this is how you prove it. You have to bring the voters register. Because under the Electoral Act, we call it a secret balloting. Forget the thing Buhari did, displaying his... You are not supposed to show... In fact, by the Electoral Act, you are not allowed to carry your phone into the voting cubicle, right? So you have to obtain the CTC of the voters register to show that your name was not ticked. You must also adduce evidence that you were there to vote and you were not allowed to vote. It is provable. I believe we should test it. I'm always in favor of testing things in courts. The fact that it has not been done before is why it should be done.
Yeah.
So a class action is hard because the law on that is still evolving. It is very rare in Nigeria to see that. If you look at the rules of courts for class action, the requirements are just something else. What is common is representative action, where some people can bring an action on behalf of a group. But class action, it is a very difficult thing to do. But if there are citizens who were disenfranchised, they should have the right to seek redress in court because the right to vote is constitutional. And if that is breached, someone should sue.
Okay. I think we are rounding up. We will be rounding up right now. But there's a question here. I don't know whether you would like to take that question. I think you've made your opinion on it publicly. It's on the 25% FCT. This person says, Mr. Inibehe, can you explain? Where is it now? It just jumped up. Okay, can you explain your position on 25% FCT and why it differs from Falanas? I don't know whether you've already said it differed. And then let me also go to another question. So you choose the one you want to. If you want to answer that, fine. If you don't want to, it's okay. Please, another person says, Peter says, please, my question is there anything that can happen today and the INEC declare president-elect will not be sworn in? I think that question has already been answered several times.
An act of God. The only thing that can happen is an act of God. And law, an act of God is an act that is beyond human control. It's what you and I cannot control.
Okay, on that.
On the issue of 25%, I've addressed that succinctly. Let's allow the courts to give an. There are two schools of thought on the matter. There are two schools of thought. I was even reading Chief Mike Ezekome's. I recommend Chief Mike Ezekome's piece on the matter. Just Google Chief Mike Ezekome 25% FCT. It will pop up. The article will pop up. Read it. Read that of Mr. Femi Falana, and then decide where you stand. There are two leading opinions on the matter. I have my own opinion, but I have also explained what I try to do in a platform like this is to keep the argument very objective. Yeah. Explain the argument for and against, and we wait and see where the pendulum will swing.
Okay, I think we're coming to that place where we'll be talking about our final thoughts. We are already over two and a half hours. It's really been an interesting and educative moment being with you. This was supposed to be just only last week, and our barrister here, even though he doesn't like being called a barrister, but he is our barrister, decided to come in here and continue the lecture, and it's really been interesting. For me, what this whole 2-week session we've had has really done is to dispel all of that social media, just pushing, overblowing the narrative and stuff like that. Let's focus on the issues, let's focus on evidence, and let's just focus on the petitions and not just what we want to see, but what is it that we have the evidence to be able to prove. The law doesn't care whatever happens. All it's interested in is that evidence, and we must focus also on the judges, and also to say to citizens, forget the narrative, forget the psychological warfare going on. Just focus on the issue, and let's not be quick to say that Nigeria is a country where things don't happen. This thing will not work very well. It's not going to be that way. No, that's not it. What we must focus on is to say, what are we going to do to make things work in Nigeria? If they feel that the judiciary hasn't been doing the things that they're doing, this is the time to say, what are the incentives you need to give to the judiciary for them to ensure they do the needful? And when I say incentive, what are those enabling environment? And one of them will be to focus on the judiciary, to not give them this room for them to be able to say to, people will believe anything we do, we can get away with it. No, they can't. Citizens must be focused, participate, be mindful, watch out, and let them know that we are all involved in this case, just the way, and also hold them accountable. I think that's what we need to do. We saw what happened by citizens participating in the electoral process. They were able to change the whole narrative of the electoral process, that now different from what you have before. People will just simply say, oh, our votes don't count, and they don't actually come out to vote. But by participating, they were able to change the narrative and change the environment. And so we also should be doing that with the judges. I will go over to Mr. Inibehe and give him opportunity to give us a final word. What do you want us to do? What do you think we should do? What are the things that we should know about as we go on waiting for the petition, the tribunal to commence itself? Thank you. We can't hear you. Can you hear me?
It must be his network, because I can hear you.
Okay, you can. Okay, thank you so much, Dudu, for that. I was thinking it's okay. Probably his network has. Okay, you are back.
I can hear you. I can hear you. Yeah.
Okay, go ahead. Just give us your closing thoughts and.
For me, it's just to thank you, Aisha, once again for putting this together. and to also commend all the participants who have made our time to be part of the discussion. I hope we learned one or two things. I am also learning myself. I encourage everyone to follow the process. Let's see whether what the outcome will be. And let us also hope that the proceedings will be transmitted live. That will further, reduce the anxiety and the apprehension that people have. And let's hope for the best for our country while preparing for the worst.
Thank you so much for that. And on behalf of the over 1,000 people that are on YouTube, some of them, we took their questions, all of them are not here, and also our 30 participants here in Zoom, we say thank you so much for taking our time to be here and educate us. And for me to say to everyone also, next week, Saturday, this hopefully is going to be a weekly program that we'll be having live with Aisha. Next week, Saturday, we'll be bringing in the chairman of the Labour Party, Barrister Abure, for us to have discussion and we're able to opportunity to also ask them questions for those who are interested in the party, what is the party doing, and then how to join the party. That will also be an opportunity to ask all the questions that we need to ask. Thank you so much, everyone, for joining us today and being part of this program live with Aisha. Hopefully we come back next week, the same time on Saturday at 6 p.m. Nigerian time. That's West African time. Thank you so much, everyone. And thank you so much to our guest also, Mr. Inibehe Effiong. God bless you abundantly. Thank you, everyone. And bye-bye.